I'm Graham Swain and I've got Patrick Oliver with me. Patrick, you're a medical negligence lawyer. Can you tell me what someone should do if they have a claim?
Well, the first thing you should do, really as quickly as you can, is to consult a solicitor.
How do you assess a case?
Quite often we advise clients to start by making a formal complaint under the NHS complaints procedure. And that's directed to the hospital trust involved, or sometimes if there's a GP involved, it'll be directed to the surgery and the practice manager there.
How long does it take to assess a case?
The first stage in investigating a case, once the funding issues are sorted out, is to request all of the relevant medical records. Once we've got the records collated and indexed, we then look at what kind of experts we need to comment on the case. And obviously, the discipline of the expert relates to the discipline of the individuals involved in the treatment to begin with that's being complained about. Sometimes you will need experts in relation to two separate issues, one being breach of duty and one being causation. Sometimes one expert will suffice for both. But once an expert is instructed, broadly speaking, it could take anywhere from 1 to possibly 3 months, depending on their waiting list and how much in demand they are. In exceptional cases where you're after a highly specialized expert, so someone who does an area of work that is quite esoteric, it could take several months for a report to be obtained.
Will I have to pay for any of the investigations you make?
We guarantee to all of our clients that if you come to us, we offer to put you onto a no-win, no-fee agreement and we investigate your case. And the case does not proceed for whatever reason at a later stage, we will not charge you for anything.
Does it matter if I live away from this area?
We are a national firm and we deal with clients as far away as Liverpool. And most of our dealings with them are by email, sometimes video link, and by telephone. Generally speaking, it will not be just one person who works on your case. There will be a team of people there because we believe that pooling knowledge and resources is much more to the advantage of the client than just one person. We deal with cerebral palsy claims involving brain damage to babies at the time of their birth or shortly after birth. We deal with serious spinal injuries where people have suffered an injury and may have paraplegia or quadriplegia. And those involve a huge amount of work, expert evidence, and indeed quite a lot of work in determining their value because these people are so badly injured they require a huge amount of care well into the future. And right to the other end of the spectrum, we deal with what you might term as a simpler case where there's been a misdiagnosis of a fracture and maybe an extended period of unnecessary pain and suffering or a delay to treatment, which may not have cataclysmic consequences for the client, but yet has caused them a huge amount of inconvenience and discomfort. And we are quite happy to work with cases which may be deemed to be low value, but nonetheless we believe they're equally important to the clients that are bringing them to us.
Do you need a lot of medical knowledge to do this work?
Litigation like this is often reliant on independent medical experts, and indeed independent medical experts are the ones who give the evidence to the court in relation to cases. In order for us to risk assess cases to determine whether or not they're worth pursuing, we pool our knowledge as a team, our knowledge and resources. Each of us has a vast amount of experience with a full range of cases ranging from the most valuable and serious injuries to very minor injuries with very few consequences. That wealth of knowledge is very helpful, and we can often discuss in great detail injuries and treatment modes and things like that. But we also have tremendous resources here at the office that we use, medical resources that we use to research cases, research medical conditions. And as I said, when we get to the advanced stages of litigation, to instructing independent medical experts, well, they're the ones who provide the backbone of the case and are able to explain in considerable detail where the medical failings have been and whether we're likely to take the case forward or not.
How do you work out what a case is worth?
I think the easiest way to explain it is to start with the distinction between the two types of compensation that a client could get if their case is successful. The first is referred to as general damages. The second is referred to as special damages. General damages refer to the compensation you get for your pain and suffering as a result of the negligent treatment. That's quite often difficult to determine because it's based on court precedent. In other words, the level of compensation you will get for your pain and suffering is gauged against cases where awards have been made for similar injuries. But of course, a lawyer will quickly find out that no two injuries are alike, and so it's often quite difficult to get an accurate feel for what those damages are likely to be. The second element of damages are the special damages. And special damages relate to specific financial losses like loss of earnings. So if I'm injured and because of that injury I can no longer work, one of the biggest elements of special damages is your loss of earnings. It could be a loss of pension. It could be extra care and assistance you need at home as a result of the injury.